Section 53(2) of the Law of Property Act makes it quite clear that these rules around writing only apply to express trusts, and that makes sense because although, as I made clear in the first talk that I did, Professor Swadling and presumably his colleagues have quite specific ideas about where the line between constructive and resulting trust falls, which not all academics share. I don't mean to imply that Professor Swadling is wrong. I have no skin in this game. It's very much between the academics themselves. But it does, the statute itself makes clear that there's no point insisting on written evidence where you've got an implied or a constructive or resulting trust, because the very point of those is that they weren't deliberately or expressly created. So you're not going to, the court isn't going to be asking for written evidence of this. And this is important if you do have a problem question about whether or not a constructive or resulting trust is arising of land. You shouldn't be looking for whether or not there was writing. You might have a case of maybe a failed resulting trust where the initial creation of the trust was or was not made by writing, and then something else happens, or so and so dies, or the beneficiary doesn't exhaust all the benefits of the land, or it was never transferred to them, and so when they die you might have a failed express trust resulting trust back. So you originally had land putting it into writing putting the land into trust. But just be really careful in your distinctions. You only got this writing requirement to prove an express trust. Now, Professor Swadling and his colleagues take a real issue. Their exact words are, the reasoning of which is incomprehensible, to the family homes cases. Family homes case is really important that you read up on this, and I suggest that you go into your textbook and have a look at what they say. Very, very briefly, Jones and Kernot is the most recent case, and what they said in this case is, where it's clear where a couple buy a house together, and it's obvious that they don't mean to share it 50-50, then the court is able to go in and basically impute what they think the intention was as to how to share the equity of the house, if the matter is brought before the court, and this creates a trust of maybe one person holding a certain percentage of the house on trust for the other. Swadling et al. Take real issue with this. They say that this isn't actually a type of trust, and the reasoning doesn't make any sense. The difficulty with this, as with a lot of trust law, and none of the textbooks will probably say this, is that an awful lot of the rules and an awful lot of the leading cases are done to basically help a party that's being treated unfairly by the law. And so these principles get created and they get twisted a little bit to try and help the people that were actually in court on that day. Jones and Kernot was a case of, I think, a woman who had been, she had bought a house, and her partner, Mr. Kernot, had come to live with her for many, many years, and they had children together. And then they broke up and he moved out of I think it was her house. But they lived together for a long time. They broke up. He paid maintenance. He paid probably parts of the mortgage. I think he paid for some improvements to be done on the house while he was still living there. Years later, she tries to sell the house, and he claims that the sale proceeds should be split 50-50 because they owned it equally. And in many cases, a couple will own something equally or as tenants in common when they buy the house, but they didn't say in this circumstance how much each of them was going to own from the outset. Now, the problem with this is Miss Jones's contribution was a lot larger than Mr. Kernot's, and Mr. Kernot had moved out a long time ago. And so the court said, well, she is holding 10% of the property on trust for him, because it was obvious once he had moved out, that their intentions towards property ownership would have changed. It's a little bit of a fudge. I probably agree with that. I think you have to look a little bit further in terms of the reasoning of this, a little bit into the wider law. You don't cover family law in your course. Probably best that you don't, because it probably doesn't have a whole lot of relevance to Ugandan law. UK family law is very specific to the UK. But in the UK, and I don't know whether this is similar to what you have, when a couple are divorcing, so they've been married and they're divorcing, the courts, the family courts, have jurisdiction to be able to basically go in and split up any marital property, no matter whose name it's in a way that creates a fair division. So if they've been married a long time, but all the property's in the husband's name, then the court says, fine, you've been married a long time, this is all marital property and it should be split 50-50. And so they go in and they can make orders to have everything split 50-50. And the problem with the family homes cases is that these are cohabiting couples. So there isn't actually marriage and there isn't actually divorce. And so for Miss Jones and Mr. Kernot, if they were a divorcing couple, well, the court would have had the ability to say, depending on what the arguments were and what the situation was and what which each person needed coming out of the marriage, they would have had the ability to say, this is how the property should be split in a way that was fair. And clearly in this circumstance, and I think with a lot of the family homes cases, what they say is, well, it's not fair that it gets split 50-50 because one partner has made a much bigger contribution than the other. And so they're basically using trust law to kind of create the same situation that they would have had, the kind of jurisdiction that the court would have had if the couple were divorcing. Now, that's my personal opinion, so I wouldn't start quoting that. But I think that might be able to give you a little bit of background when you go, and you will need to go away and read the textbooks about the family homes cases and decide what you think about them for yourself, and whether or not you can see the rationale that various academics give to this line of cases.